The United States Supreme Court case law, Brady v. Maryland, Mississippi, King v. State, and also Arizona v. Virginia, which is a U.S. Supreme Court state. The failure of law enforcement to disclose exculpatory evidence is imputed to the state, and such disclosure mandates either a continuance until the defense has had time to review this documentation or dismissal of the charges themselves with the failure to provide exculpatory evidence in discovery.
You want to mark?
Yes, Your Honor, I would like to mark on Friday.
All right, I'll be marked Friday purposes only.
Can we look at it? Yeah, got a copy right here.
I mean, I have a response in general without looking at them.
Hang on. Take a look at them. Where they marked?
23 hours.
23 ID only.
Your Honor. The date is on the top text message. There's the one in general that we believe goes to the exculpatory evidence. It is on this page. So it would be the fifth page. PG is in blue, Carly is the black.
Where's this do it back? Is that the first text message?
Yes.
All right. So the defendant says do it back. Mr. Bennett, Germany says, I don't know what that is. What's going on? She responds, I don't know. I called Anthony because I wanted to talk to him, and then I saw him and I couldn't breathe, and I couldn't say anything because I didn't know what to say, and I can't remember anything that happened today. I zoned out for most of it, and I don't know what's wrong with me. That's what you're saying is the exculpatory part?
Yes, Your Honor. And that this text thread is dated as of November 22nd of 2023.
All right, anything further from the defendant? By way of motion.
No, Your Honor, just that the U.S. Supreme Court and also the Mississippi State Supreme Court is clear about the failure of the fact that it was in the possession of law enforcement. Law enforcement downloaded the contents of this phone, had it by search warrant and failed to produce it, and the failure, and according to the U.S. Supreme Court in Arizona v. Youngblood, the failure of law enforcement is imputed to the failure of the state for discovery purposes.
Okay. Response by the state, or do you need a few moments?
I'm prepared, Your Honor. First of all, I don't believe that text message.
Let's step up to the podium.
I may have to go upstairs at some point and get a signed piece of paper from Ms. Todd, but I think that I have it here. Your Honor, first let me address the fact that this is not, in fact, exculpatory material. This is a text message between Bennett, Germany, and the defendant from back in November. Bennett, Germany took the stand. He could have provided this at any point. He actually, in fact, spoke to the defense attorneys previously. This is not new information that they had. It's not exculpatory information. However, in order for it to be a Brady violation, the state would, in fact, not have had to produce the material that they had. On June the 4th, 2024, the state of Mississippi provided to the defense attorneys one jump drive containing digital evidence media files, witness interviews of minor friends, the indictment, discovery bait stamps 1 through 349, supplemental discovery bait stamps 350, 351, third Snapchat report 352, 356, 2 CDs labeled Heath Smiley hospital interview and Deputy Allison Dufour body cam, and 1 hard drive containing phone dumps. Your Honor, they were in fact provided the phone extraction from Bennett, Germany's phone. It is not the state's fault that they did not review those messages. Everything that was on Bennett's phone that was taken from law enforcement was produced to the defense attorney on June the 4th, 2024. Since there had been issues with the state of Mississippi and the defense attorneys claiming that they had not in fact received items, the state went ahead and had them sign something stating that they had received discovery, and also the entire jump drive, now not the external hard drive, but the jump drive that was provided that had the media and electronic data on it was screenshotted. Ms. Todd signed off on April the 20th, 2024, that she had received all those items, including through bait stamps number 798. When Mr. Camp reached out to me the day before the defense attorneys had provided their expert discovery, I believe it's by email, I can go back and look, Your Honor, I believe responding to him around 5 o'clock, he said something to the effect of, where are the text messages between the kids? And my response was, well, there's two places. There's screenshots that you guys were provided, and then there's messages within the actual phone extractions. Your Honor, they had this material, they knew this material existed, and for them to try to claim now that they were not provided that information is disingenuous. And again, this witness took the stand. If they knew this, if he knew this, if they had this information, they met with him previously, why on earth would they be producing it now? We do not believe this is exculpatory. This is something that happened back in November. We're here because the state has charged Carly Gregg with murdering her mother on March the 19th, 2024. We are here because the state has charged Carly Gregg with attempting to murder her stepfather, Heath Smiley, on March the 19th, 2024. And we are here because the state has charged Carly Gregg with tampering with physical evidence for removing the surveillance footage that captured a portion of the incident and hid it in the refrigerator. There is nothing about this text message that would indicate that it is anything other than messages between the defendant and one of her friends who on the stand said he was her best friend. This has not been authenticated. I don't know, Your Honor, without going and putting the phone extraction into my computer whether or not this message is actually there. But if it is, they've had it since June.
Hold on a second.
May I respond, Your Honor?
In a second. I'm going to give you a chance to reply. All right. What documentation do you have to prove that you turned this over to the defense? I believe you said there was a jump drive that contained the phone extract, and I'm familiar with phone extractions, that there's no way to extract part of a phone on Celebrite.
That's right, Your Honor.
Okay. So did you show me what you got to prove that you turned over a jump drive?
Of course,
And if you need a few minutes to go grab your paperwork, you
I
go.
do not, Judge.
Show it to counsel opposite.
We've had this issue come up previously, so now we have the defense attorney sign saying they picked up material.
All right. Do you have a copy of that we can mark for identification
This is the
purposes?
only one I have, Your Honor. I can rip it out of the file and make a copy if necessary. Thank you.
All right. You showed it to counsel opposite, correct?
Yes, Your Honor.
All right. Mark it for identification purposes for the state.
Your Honor, for the record, that bears Ms. Todd's signature and date.
Okay. Let's mark it so I can see it. All right, and what you're saying is this jump drive contained digital discovery. Is that correct?
Your Honor, there was a jump drive that the defense brought to our office. That jump drive contained the digital discovery, the physical file, the PDFs, the 2 CDs that we had in our file, as well as we had an external hard drive that had these phone extractions on them. They were put onto the jump drive that Ms. Todd picked up on June the 4th, 2024, as indicated by a hard drive containing phone dumps. Your Honor, there are multiple emails between myself and Ms. Todd that if I need to, I can run upstairs and print off where I've said, let me know if you can't open a file. Let me know if you don't have something. I said, in fact, hey, I screenshotted 800 pages and scanned it in. Let me know if a single file doesn't open. Mr. Camp and Ms. Todd were attached to all those messages. At no point did they ever say, hey, we don't have Bennett's phone extraction. Again, just because they don't know how to access something, they didn't ask our office for something, or they didn't take the time to review that material, Judge, does not put that burden on the state.
Is there anything else the state wants to move in for the court to look at.
Your Honor, I'd like an opportunity to go upstairs and print all those emails I've talked about, if that would assist the court in any way.
Sure. Can you do it within 10 minutes?
I believe so.
All right, we'll be in recess 10 minutes.
In fact,
I won't
Mayor,
give you a chance to reply, but I want to see her. It's going to go motion, response, reply, I rule, we're done.
I believe my reply was cleared up, Your Honor.
Nope, not till I see her documents. I want to complete the state's response. That way you can have a reply. We're not going to have a reply, response, reply. It's going to be motion, response, reply, I rule, and the rest of it's up to the appellate courts. All right, y'all got 10 minutes.
Your Honor, I believe that I could probably just make a copy of all of this, and that would entail my emails back and forth with Ms. Todd regarding discovery. I kept them because I assumed that there at some point would be some sort of argument that we hadn't produced something, but I do not have a copy of this. This is just the one copy I kept for my file.
Well, I saw Mr. McDivitt stand up back there. He can make himself useful and cut down on the jury's time. I think everybody in the courtroom knows I don't have a problem abusing lawyers and their staff. So give him the email, the email. Mr. McDivitt, you go copy it.
I think that should be everything. I'm gonna make sure that's all of it.
And please bear in mind, I got a jury waiting.
The problem is there's a bunch of staples in it, but I don't know what I got. But I'll keep it. Thanks, sir.
All right. Ms. Gugliano, still don't discuss your testimony with anybody. Well, let me ask this. While he's making copies, would there be some objection to us going on ahead and hearing her testimony? I mean, you're asking me to dismiss the charges, basically, Ms. Todd, correct?
Yeah.
Okay. Well, if I don't decide to dismiss the charges, we're going to hear Ms. Gugliano's testimony anyway. So rather than wasting the jury's time, I'm going to bring the jury in, let you cross-examine her, let them redirect, and then I can take another break, and maybe copies will be done by then. I'll hear objections to that procedure by the state.
No objection.
Objections to that procedure by the defense.
No, Your Honor.
All right, let's bring in the jury.
Well, let's get to our break while they bring in the jury. That's a big ask that the defense has right there. They want to get these charges thrown out because of a discovery violation. Reminds us of what happened in the Alec Baldwin case when there was a discovery violation allegation in the middle of trial. Let's get to a break, get you back in, picking it up with the testimony of Dr. Amanda Gugliano.